Okay. Good morning, everybody, and welcome to the hearing. If anybody has any time, any of the submitters, well, I'll wait till, for the benefit of those people that are online, any time constraints, please let the Council Officer, Mrs Lindsay Crazywolf, know. And there's more supplementary planning evidence online. This is hearing stream 3 concerning rural zone, and Keith, I believe you've got a comment as per conflict or potential.
Yeah, thank you. There were 3 submission points by Clark, Fortune and McDonald that relate to properties that I join or overlook in the 99.001, 0.002 and 0.046, and I will not be partaking in decision making on those points. And I'll repeat that when Clark, Fortune, McDonald come along.
Thank you, Keith. No one else got any conflicts at this stage? We'll now hand over to Joe, is that correct? And Mr. Garbutt.
Oh, good morning, hearing panel. Kia ora koutou, everybody. My name is Michael Garbutt. I'm the solicitor appearing on behalf of Gore District Council. There is just one legal matter I just wanted to address you on, and it's one that I foreshadowed and outlined in my legal submissions that I filed whenever they went in, 18 July. And I just want to address you on that briefly so you understand what I'm saying. And that's Mr. Ben Wilson for Clark, Fortune, McDonald, who you're going to hear from today, and his evidence raised what's essentially a procedural matter and asked that decision making on the 8 hectare minimum lot size be deferred, and he alleges that there's inadequate or a lack of Section 32 assessment for that rule. And in response, I've filed written submissions addressing that in full, but I just wanted to highlight for you that that allegation is absolutely refuted in the sense that the officers who worked on the plan change have in my submissions set out on the website and in the relevant Section 32 materials a very structured and thorough Section 32 analysis of the rural zone. And I did set out in my submissions, in paragraph 18, a range of steps that they went through in carrying out that assessment. And just by way of highlight, you know, there is a full description of the problem that was sought to be addressed, being protecting the general rural zone from fragmentation and maintaining rural productivity. A discussion of the issues that the current 2 hectare minimum lot size create, including rural lifestyle proliferation in the district, assessment of the effectiveness of the provisions, summary of technical reports, analysis of other councils' approaches around the country to this issue, assessment of the scale and significance of the issue to the district, including the main costs, summary of feedback on the draft, assessment of the zone structure, creating a rural zone, distinguishing it from rural lifestyle and settlement, a full assessment of the objectives, policies and rules, and an evaluation specifically of the status quo rule of 2 hectares compared with the 8 hectare rule proposed, and a bigger 40 hectare minimum lot size, and the 2 hectare and 40 hectare option were discounted by the officers. So to say that there's no or inadequate Section 32 is just not accepted. So my submission is that the Section 32 material is very structured, it's very professional, it looks at the tests in the Act under Section 32, it also looks at best practice around the country about what other councils are doing, and comes to a conclusion that the officers have landed on what they see as the most appropriate provision. Now, any submitter can obviously submit to you, as Clark, Fortune and McDonald has done, that they're entitled to bring forward to you other costs or benefits or other analysis that they say that you should take into account in addition to build on the Section 32. and they're entitled to do that, and this is their opportunity. But to allege that what the council's done is inadequate and that decision-making should be ceased or halted on that, in my submission, is just out of line and not justified by the materials that are in front of you and everybody else. So that's the legal submission I want to make. I don't see there's any basis to delay decision-making on that rule, and I think you should hear from Clark Fortune, but I just wanted to raise that initially as the response on behalf of the council to that allegation. I'll hand over to the officers. I know they've got a lot of material. I'm obviously happy to answer questions about that at all. Otherwise, I think it's time for you to hear from the officers.
I do remember that submission. What was that gentleman's name again?
It was Mr. Ben Wilson
Yes,
for
Wilson.
Clark Fortune McDonald, who you're hearing from this afternoon.
Yep. Thank you.
Thank you.
Well, we have you then. You mentioned section 32, and I'm wondering, in considering section 32, and it really arises from matters that we heard yesterday, is the potential cost to council of putting things in the plan or council doing additional work a matter that we should have regard to under section 32?
So section 32 is pretty generic in its wording, and it requires an assessment of the benefits and costs of the environmental, economic, social and cultural effects anticipated from implementing provisions. It is cast in probably as broader terms as you can possibly imagine under the RMA. It doesn't differentiate between council costs or those on landowners or the community or anyone else. So yes, I would submit that costs to the council are relevant, alongside costs to anybody else who brings forward evidence of costs or benefits related to the provisions.
Thank you. Thank you. Now, in terms of moving forward, so we've got planners, but we've also got a couple of experts online. I'm just wondering whether we deal with those people first, whether that's your intent.
So I had intended to give you a very brief overview of the section 42A. Obviously, I know there's a lot of content in there. I was going to pretty much keep it to the sort of more major changes that I've made, and then take you through my supplementary evidence based on the submitters that we have present today. There are 2 submitters that will be here tomorrow, and my intention was potentially to introduce my supplementary evidence in relation to those 2 submitters tomorrow. We will have 3 experts online. Ruth Allen, who is the author of the growth reports that were attachments to my 42A. Mark Gregory, who's the transport engineer, who gave specific advice on 2 rezoning requests. And Tim Morris, the senior civil engineer, who authored the flood hazard report that also informed some of our rezoning decisions. If the panel has questions ready to go in relation to the experts, we can do that first, and then I can give my summaries of my reports. It's up to the panel.
Yeah, I've got no questions, so we'll hear from you.
So, yeah.
I'll go first.
Yeah, do your intro first, and then we'll go to them.
Okay, so I appreciate that there is a lot of content in the 42A and also in those attachments. In terms of the changes, or the sort of more crucial changes, we rezoned various areas in East Gore, Waikaka and Mataura based on the expert evidence in terms of flood risk. We proposed a new precinct for the New Vale mine in recognition of their existing activities and the proposed ecological enhancements they intend to do in the future, and also the provisions in that precinct enabled mining extension, although through a further resource consent. The setback to the state highway in the general rural zone was reduced from 100 metres to 50 metres. We increased the scale of permitted rural industry activities following review of some existing activities in the area, and actually in terms of those types of rural industry sort of contractor yards and the different equipment and transportation needs, those permitted clauses were increased slightly to actually enable suitable rural industry activity. We increased the building coverage in the rural lifestyle zone based on submissions. You'll see there's quite a large section in the 42A on definitions. We did receive lots of submissions, either sort of asking for clarity or asking for updates in relation to new national direction. And then generally, in terms of objectives and policies, there were lots of submissions from various stakeholders to improve the usability of the plan, and they are all detailed in the Appendix A of that 42A report. And we also added a restricted discretionary consenting pathway for additional minor units in the general rural zone, and this is in relation to supporting that primary production activity for things like workers' accommodation. In relation to my supplementary evidence, I will just take you through that now. I'll focus, as I said, on the submitters that we're hearing from today and any consequential changes I made, having reviewed the evidence that was received. Firstly, there are a few errors in my 42A report in relation to paragraph numbers, which I apologise. So they're mainly towards the end of the report. I have set them out in paragraph 7. I can read through them if you like. Okay, great. Okay. So I acknowledge the support and the evidence received for recommended changes, and I'll just set out any sort of further changes I've made on receipt of that evidence. So firstly, in relation to Clark Fortune MacDonald, the submitter is still opposed to the proposed setback for residential units in the general rural zone. I stand by my recommendation of a 30-metre setback, but in relation to recognising that, given that we've had a smaller setback up until now, that there are existing buildings within those setbacks, I propose an exemption to the rules relating to primary production buildings and residential activity and allowing extensions to those buildings, provided that they don't exacerbate any standard, i.e. if you've got a building within the setback, you can extend it so long as it's not extending further into the setback. I hope that this provides some relief to existing buildings that we obviously have in the district as of now. In relation to the settlement zone, we received submissions in relation to the existing built form patterns, and I guess because we've ground truthed the settlement zones, and whereas they were previously just rural, they now have their own zone in recognition of the townships. Obviously, we need to put forward standards that enable residential activity and also maintain the character of the area. It wasn't an easy task, given that they've sort of organically grown and the lots in those townships are all quite different. The main issue put forward by Mr. Wilson was in relation to the lot size and the requirement for consent if you were less than 2,000 metres squared. Mr. Wilson put forward that there is a sort of historic subdivision pattern of quarter-acre lots, which are about 1,000 metres squared, and didn't think that a non-complying activity consent was appropriate for those wishing to build residential houses on those lots. I appreciate where Mr. Wilson is coming from, and having reviewed again the settlement zones, I do agree that there is a variety of lot sizes, and it's not my intention to prevent residential activity in those townships. However, given the smaller lot sizes, I do think that it is an important consideration in terms of on-site servicing. So therefore, I've recommended an amendment to the density rule, which is sets S1, in relation to lot size, and enabled a residential activity or building to be built on lots between 1,000 metres squared, provided a restricted discretionary activity is applied for with matters of discretion restricted to on-site servicing and also natural hazards, in the hope that this provides an easier pathway to obtain consent, but still addresses my matters of concern, which would be on-site servicing and natural hazards. Equally,
while you're on that, can I just ask a question? So The township zones have a number of lots in them of 1,012 square metres, which is your 1/8 of an acre. And the existing 2,000 square metre provision comes from originally, I think, out of the subdivision development bylaw, where the advice given was that that's the size site you needed if you didn't have sewage disposal, so for a septic tank. So what's in your recommendation in order to keep the character of those zones? Is it your intent that the 1,000 square metre rule only applies to existing sections, so that any further subdivision that takes place is all at the 2,000 square metres moving forward? Because the way your rule's written enables us a restricted discretionary to create 1,000 square metre lots.
Yeah. Given that we already have quite a few existing 1,000 metre squared lots, I don't consider that there would be a huge change in terms of that character to enable lots down to 1,000 square metres. So the way the rule is written, it does enable sort of a higher density of development if the on-site servicing enables it.
So why not allow as a permitted activity at 1,000 square metres if they're connected to a sewerage scheme?
If they're connected to a sewerage scheme, then that is a possibility. And only Waikaka has reticulated sewage at the moment. Yeah. That is something for the panel to consider. But we still have, as has been raised through submissions, there are issues of natural hazards in the settlement zones. So I do consider, obviously, if we go down to 1,000 metres squared, it's an increase in development potential, and therefore I do think that natural hazards need to be addressed or flagged through that restricted discretionary rule. Okay. In relation to those in the settlement zones, Mr. Wilson also raised issue with the setbacks. I have reviewed existing buildings in those areas and do understand in terms of those smaller lots that the setbacks could be overly restrictive. I have therefore recommended that they be reduced. This is still keeping in mind that there is a coverage rule, so whilst buildings may be closer to buildings boundaries, they are still restricted in terms of the level of built form enabled in the zone. Okay, the next submission that I will address is from KiwiRail. So we heard a lot from KiwiRail in hearing stream 2 in relation to their request for a 5 metre setback from boundaries. Through the hearing stream 2 right of reply, there was a request from the panel for KiwiRail to provide additional information. And the officers of the hearing stream 2 therefore responded to that information and made a recommendation in relation to setbacks for zones, the commercial zones and the open space zones. KiwiRail have submitted across the entire plan in relation to these setbacks, so whilst a lot of discussion went into hearing stream 2, we still have submission points that we have and will address throughout the rest of the hearings. Our intention is to be as consistent as possible in relation to the standards that we recommend, but also bearing in mind that these may change or need to be adjusted in relation to the zones that they then relate to. So in relation to the rural zones, in the general rural zone, I have not recommended a setback on the basis that we already have reasonably large setbacks proposed in the rural zone, but I have included a matter of discretion in the setback rule should a building be in proximity to the rail corridor. In the rural lifestyle zone, the rail corridor doesn't pass through any areas that we've rezoned rural lifestyle, so I have not included a standard in that regard. In the settlement zone, we do have the rail corridor passing through Pukerau, and therefore I have recommended a setback standard for buildings in proximity to the rail corridor. These are in relation to the height of the building, so it's almost like the taller the building, the further it needs to be set back. The standard is detailed at paragraph 36.
So the standard that you've got there, and there's only one property at Pukerau that's affected by this, and it's next door to the industrial area.
Right.
The state highway is the boundary for the rest of Pukerau. But under your new rule, you say that any building no greater than 3 metres in height shall be set back a metre from the legal boundary with the railway line. So that's under S10. But if I go to S5, that says any building or structure is to be set back 2 metres from the side or rear boundary, which is adjacent to the railway. So we've got an inconsistency there between S10 and S5.
Yep. I guess in relation to that, if someone was to breach that 2 metre standard, this standard would also kick in if they were in relation to, if they're in proximity to the rail corridor.
But if you can't, if you can't have, it's just the number one in terms of 1 metre back is nonsense, because you've got to be 2 metres back because of the other rules.
Okay. We can remove clause 1.
Yes, yes. Thank you.
Just wondering whether there's you might need an additional, I haven't got it in front of me, Joe, but whether you might need an additional matter of discretion in the first rule.
Yeah, well, what I was thinking was that S5 and S10 can be amalgamated together, and then it overcomes any inconsistencies between the rules. Because even number 2 in S10 refers to a setback of 1.5. So it's only buildings over 5 metres high that actually need a bigger setback than what's in the rule.
Yeah, I guess we just have to ensure that if somebody breaches that setback, that we've got discretion to consider the rail corridor. We did look at amalgamating the rules, and Kiwi Rail were quite adamant that they wanted a separate standard. I think there is more detail in terms of that discussion and assessment in that hearing stream 2 right of reply.
Right, okay.
Okay. The Department of Conservation has reviewed the 42A and provided support in terms of objectives and policy changes. They did have a request that in relation to the General Rural Zone, Rule 3, they had an amendment to the matters of discretion in relation to ecological values. They wanted to include the effects hierarchy in there, which I support.
Joe, can you just explain that rule, and you've got, and the potential for compensation or offsetting where appropriate? What would that cover? That's on page 12, 57.
Yes, so Rule 3 in the rural zone is in relation to quarrying activities. So we included an additional matter of discretion with the Section 42A report in chief to include an assessment of effects on ecology values, including Indigenous biodiversity. And then the Department of Conservation asked for the additional words to be added in terms of the effects hierarchy. And this is to align with the wording of the National Policy Statement for Indigenous Biodiversity relating to compensation and offsetting. So it does enable an assessment, and part of that assessment you can look at offsetting or compensation through the resource consent process. So that could be additional planting elsewhere, or increasing or bettering wetland areas and the likes. I guess it's the matter of discretion is almost, in a way, a good steer for applicants to understand our sort of expectations for those activities if you are breaching those permitted clauses.
Just on that, So presumably this matter of the effects hierarchy gets addressed when we hit the eco topic, because one thing that I note when I read this drafting is that while all the elements of the hierarchy are present, the hierarchy itself isn't present. So I'm presuming that when we get to the eco chapter, the effects management hierarchy is dealt with, and so I guess it's a wee flag from me that we need to know that we were making these kind of changes in individual rules and other parts of the plan, I'm presuming that the eco chapter sort of has some provenance, and it will in fact direct this matter.
Mm-hmm.
Yeah.
Yes, originally this matter of discretion was added through my 42A report, and at the time of drafting, I guess my sort of first thought went to, if there's ecological matters to be addressed or Indigenous biodiversity, it will be addressed in the eco chapter. However, on reading the submission from the Department of Conservation and Forest and Bird, I did consider that given that it is an important matter to be considered, and I wanted it to be really clear that those aspects are important in terms of this activity in this area. So that was the reason for including the matter of discretion in the first place. But yes, I see what you're saying in terms of if we introduce effects hierarchy and things, they need to make sense in terms of the other chapters or the district-wide chapters.
Yeah, because I mean, obviously the key to the hierarchy is that you first avoid then you cascade through, and you don't end up at compensation or offsetting unless you've first gone through the steps. And is this in part a response to, the limited SNA mapping and deferral of SNA mapping? Is that sort of sitting in behind this as well?
Yes, I've specifically referenced Indigenous biodiversity rather than just SNAs.
So what we've got government looking at deferring SNAs, and you've just differentiated between SNAs and Indigenous biodiversity, which is a Section 6 matter. So what do you see as the difference between SNAs and Indigenous vegetation?
Well, currently the eco chapter directs us to protect Indigenous biodiversity, not just SNAs. In my opinion, it's important to have protection of Indigenous biodiversities, and whether that extends to SNAs, I guess is a question of mapping and identifying.
What's an SNA then?
So I might be able to help here. An SNA, as defined under NPSIB, National Policy Statement of Indigenous Biodiversity, has to meet certain criteria in an appendix that's attached to the NPSIB, whereas Indigenous biodiversity is broader than just what's defined in the NPSIB. It may include Indigenous vegetation that doesn't necessarily meet those criteria, for example. So that's the distinction, and as I understand it, the deferral of mapping specifically relates to SNAs that meet the criteria in the NPSIB. But we still have an obligation to maintain Indigenous biodiversity under Section 31 of the RMA.
So I think it's a conversation worth repeating when we've got federated farmers here.
I'll move on to the submissions from the Kauai Trust. This is submission points 42, submission 42.001 and .002. This was a rezoning request from general rural to rural lifestyle. This was discussed at paragraphs 334 and 338 of my Section 42A report. At the time, although I expressed in the report that I saw merit in the location of the proposed rezoning, in terms of it being in proximity to the Gore district, aligning with the Gore golf course, and therefore strategically in terms of its placing could be suitable for rural lifestyle development, we had further submissions from NZTA with concerns over the potential traffic effects. Mr. Gregory provided further expert input in terms of this rezoning and the potential for traffic effects. Since the 42A report has been issued, I'm aware of discussions that were happening between the submitter and NZTA, and NZTA have submitted further evidence withdrawing their concerns in relation to the potential effects on the state highway in relation to the rezoning of this land, but on the proviso that there is a rule in the transport chapter as proposed that would require an integrated transport assessment for further subdivision. This is based on the traffic movements that would be generated by such a subdivision. So having reviewed the evidence put forward by the Kauai Trust, the Section 32AA provided by the submitter's representative, Mr. Ware, I do recommend that the site is upzoned to rural lifestyle. This is 205 Reby Road. The submitter has entered into evidence the subdivision consent that they have had approved, which enables a 38 lot subdivision of 2 hectare sites. I consider that this although not implemented, it can be implemented and fragments the land beyond productive use. I think this exemplifies the issues with the current district plan and the lot size, and therefore I do recommend upzoning to rural lifestyle.
Is it worth asking Mr. Gregory for his view on that approach? So is Mark online? Yes. So so the reporting planner is now indicating acceptance of the property at 205 Reby Road being rezoned to rural lifestyle. Are you comfortable with that proceeding without a traffic assessment being done prior to rezoning, or are you comfortable that the traffic assessment can be done as part of a future subdivision consent?
Thank you, sir, for the question. Since my evidence, which is filed as attachment 2, I've done some more analysis, and in short, I would be comfortable with the rezoning proceeding at this stage without an ITA. And if you like, I can set out my thoughts on that.
No, that's fine. I just wanted to get that extra box ticked off. Thank you.
Okay.
Okay, I'll move on to my response to the evidence received from Federated Farmers. So one of the things raised by both Federated Farmers and Stony Creek submitters was a request for a definition for farm infrastructure. Originally in my 42A report, I outlined that when we look at the definition of structure and the fact that it relates to things that are attached to land, there are a lot of things that I consider that the submitter was intending to exempt from setback requirements that actually probably wouldn't fall into the definition of structure. Things like water troughs and water troughs and feed troughs and that kind of thing, things that can be moved around and temporary. However, the submitters have provided further evidence in relation to this farm infrastructure, and it seems to really revolve around irrigation, irrigation pivots and their infrastructure, which actually is fixed to ground. So on this basis, I have reviewed the definition put forward from Stony Creek, which was supported by Fed Farmers, in relation to this definition of farm infrastructure. I'll just, find it in my notes. So this is on page 13 of my supplementary evidence. And I have recommended a definition which includes those structures reasonably necessary to enable primary production activities relating to irrigation and provision of stock water, but excludes fences, farm tracks, dams and reservoirs. This is to enable things like irrigation pivots that will likely need to be within the road setback. So I've recommended that we include a definition of farm infrastructure and therefore exempt farm infrastructure from the setback to roads and the setback to side and rear boundaries. The definition that was put forward by Stony Creek had additional, would permit additional structures. They had something in there in relation to sort of infrastructure necessary for the distribution of animal feed, stockyards and ramps. You'll see in my evidence that I haven't included this, as I consider we wouldn't want things such as feedlots, silage pits and food grain silos within setbacks, as these can be quite large structures. That's why I've purposely taken that out of their proposed definition.
Excuse me, Joe, there was a mention for loading ramps, was it?
Yes, so stock ramps stock ramps and stockyards and loading ramps are already exempt from the road setback, so they are enabled in the road setback. And that is included in standard GRUZ S5.
You indicated that provision could be made for bridges as well, but you haven't taken it any further with any recommended changes.
Yes, so Stony Creek's planner, Rachel Perkins, and I had informal conferencing around this definition, just to really understand what it was that they were trying to achieve. And through that conferencing, she did raise the request of this farm infrastructure being enabled in the stream setback provision. At this point in time, I don't consider that I have enough information, or I'm not comfortable with exempting the definition of, or what the definition of farm infrastructure would enable in stream setbacks. I consider that the reasons for the stream setbacks in relation to conservation and ecology, public access, there's lots of things that the stream setbacks are trying to achieve, and therefore I do consider that consents may be necessary in certain situations in order to make sure that we're still achieving those outcomes within the stream setbacks. However, I did suggest that there is potential for exemptions in there in relation to existing ramps or crossings, potentially bridges, but I think it just needs a bit of further, I guess, discussion with the submitters around what it is we're trying to achieve from that, and whether we can have some permitted clauses in the plan to either allow for existing crossings and bridges, or maybe it can depend on the order of the stream. So the smaller or the lower stream orders, there might be more provision for those types of things. I think it's something that I would be willing to have further discussions with the submitters on in terms of a right of reply, in terms of reaching agreement on what would be appropriate in terms of allowing those things.
Let's explore it further when they're here.
Yes.
Sorry, Joe, can I just ask a question? The loading ramps, are they temporary or permanent loading ramps?
It doesn't identify either or, so they would be temporary and permanent.
And they can be permanent?
Yes, they can be permanent, yeah.
And NZTA are happy with that?
They haven't further submitted on the rule, and it was notified as enabling these things. The other changes in relation to Federated Farmers' evidence, I have looked again at the education facilities rule. Fed Farmers were not comfortable with the hours of operation that was proposed on the basis that there may be education type facilities that, if they're agricultural based, have lessons and things outside of these hours, i.e. early morning milking and things, which I have taken into account. And you'll see in my evidence that based on the other clauses in the rule, which sort of limits those party sizes to about 12, I do think that we can remove the hours of operation based on the fact that the scale is still managed through those number of persons.
So they raised the hours of operation issue in relation to the vet clinics as well as the educational facilities. So is it the same response?
No, I think in relation to the commercial activities rule, the 12 employees that rule enables, whereas the education rule, 12 people would be teachers and students as a whole, 12 employees in a company there's an expectation that there might be customers visiting the site, and 12 people in terms of that scale could enable quite a large commercial operation. The hours of operation in relation to that rule are for people visiting the site, and I do acknowledge that there may be cases for vet clinics having instances of emergencies which fall outside of these hours.
That's what I was wondering. What was coming through the Fed Farmers submission did sound like an emergency response in the same way that human clinics might have similar.
Yeah, and I do acknowledge that, and I think it's something that could be explored. In relation to that, I think we can either include an exemption in the rule for this sort of emergency situation, or we could exempt vet clinics themselves from that clause, GRU as Z-R9.
And it would almost be self-policing. I've had to take one of my dogs to the vet at 3 o'clock in the morning.
Absolutely, yeah. Unfortunately, it's probably that's the case.
You wouldn't have bookings done outside those hours. So I think there is room to explore something that fits into the category of an emergency.
Yeah, so I discussed that at paragraph 89 of my supplementary evidence. Okay, Fed Farmers did also raise questions in relation to that SNA mapping, and this will be discussed at hearing stream 9. However, I am prepared obviously to take questions on it if necessary. It's anticipated hopefully that by hearing stream 9 we'll have a little bit more of a understanding from the government in terms of the amendment bill, which will hopefully be enacted, and we might just have a little bit more I guess an understanding of the way things are going. But
is Mr. Garbutt intending to be here this afternoon when Federation Farmers appear? Yes. Because I think we need to talk about the variation provisions that are sitting in the plan and likely timing of how the government's proceeding with its stuff, but we'll talk about it then.
Okay. Yes, so that concludes my supplementary evidence. I'm more than happy to take questions, which I'm sure you have. If it would be okay with the panel if we could firstly direct questions to the experts that are online, and then we can come back to me, if that's okay.
Thank you, Joe. I don't have any questions at this stage.
Do you want to go through them in alphabetical order?
Well, if there's any more questions for Mr. Gregory on the transport matters?
The only one I had was in relation that I've already asked. Thank you.
Okay.
Any questions from anyone else on the panel?
So, Mr. Gregory, because of that exchange that's happened for Kauai Trust, that's led to some level of comfort around the zoning for that proposal. We have another proposal where NZTA were signalling that they wanted to see an ITA, and there hasn't been a similar exchange. And the question in my mind is, if in the case of Kauai Trust, it can be accepted that the transport assessment will occur as part of the subdivision consenting, is there any reason to not apply a similar logic where we're dealing with another proposal in the area?
So I've given this some thought, and we're talking about the site, aren't we, between Reby Road and the Waimea Highway. In my opinion, we might seek a transport assessment for that site, just because it is closer to the state highway, and there's potential for more acute effects which could affect the state highway, such as access. And I think we would need to see that managed appropriately at the correct stage. Noting as well that obviously the support of the agency would be required in order for any development to be given effect to. Whereas I've drawn a different conclusion for the site of 205 Reby, just because it is much more removed from the state highway network, and for various other reasons as well, including aspects of the receiving environment, the crash history, and I've gone a little further and anticipated some vehicle movements as well that might use the State Highway 94 Kingdom Road intersection, for example. So in my opinion, the 205 Reby Road site, we could definitely say probably an ITA isn't required at this stage. That can be managed appropriately through the Trans R4 rule. But for the other sites, as you ask, I would, in my opinion, I think an ITA would still be useful.
I just add some more information in there. There's a little distinction between Reby Road, where the subdivision is approved, but the other one hasn't sought approval at this stage. So the trigger point might be somewhat different.
Yes,
Yes,
yeah.
Sorry.
Sorry, Mark. Yeah, that is a factor for consideration. I think in relation to the other rezoning request, from a planning point of view, we've got other matters to consider in relation to that land. One being its size, another being highly productive land, class 2 soils, and also, as Mark has alluded to, the reverse sensitivity effects on the state highway that aren't just in relation to traffic movements, but also direct access and noise reverse sensitivity.
I did pick up a lot of that from the reading. It was just good to sort of test that basic idea of the logic behind requiring something at the point of zoning and requiring something at the point of consenting. So appreciate that analysis. Thank you.
Thank you, Madam.
If there's no more questions, I see we're scheduled.
No, we've still got the other two.
Yes.
Yes, so we have Ruth Allen on the line, who is the author of the growth reports. This fed into the Section 42A in relation to those proposed amendments to rural lot size, and also in terms of enabling additional activities that support the rural zone. So if you have any questions for Ruth, thank you.
No questions from me.
It was a good read again, Ruth. I think it just reinforces the work that's been done over a number of years. So I've got no questions. It's more background to understanding how the reports have come together. Thank you.
Noted, thank you. I have no further questions, thank you.
Kia ora, I'm in a similar boat. I am aware that we do have a submitter, as Mr. Garbutt was pointing to in his legal submissions, who is querying the rural lot size still. And so, although we have that material already from you, it might be helpful just to perhaps have just a really brief synopsis of arriving at that lot size, because that is part of what's supporting the legal submissions we've received, and could be important just to make visible in a really short and simple way now.
Okay, thank you. I'll just, on that basis, give a review of where we landed in terms of 8 hectares as minimum lot size. We did quite a lot of an analysis at the time.
Excuse me, Ruth, if possible, can you move closer to your mic, perhaps? We're having trouble hearing you.
How's the sound now? Is that better?
No, look, we'll do our best, thank you. It would be fine if you wanted to shout at us. Thank you.
Just bear with me. I'll just make a couple of changes and see if I can fix the sound. Is that any better?
Yes, much.
Far better.
I was just beginning to give an overview of how we arrived at 8 hectares. We spent quite a lot of time at the time of undertaking this analysis, working through our GIS analysis to determine what lot sizes were located currently in the rural zone, to provide evidence of rural rural lifestyle properties being created within the rural zone. And that information is outlined in the report, showing that 30% of lots in the rural zone were less than 2 hectares. That led us to the point of deciding that we needed to understand what size would be required in the rural zone to prioritise rural producing farms sizes. And what we did in order to come up with 8 hectares was have a look at industry-wide information based on sort of average rural production farms. We looked at some research undertaken by Landcare in 2020, which was looking at how to avoid the fragmentation of highly productive soils. And on the basis of this research, the conclusion was, well, this research demonstrated that 80% of parcels supporting dairy farmland and 70% of sheep and beef lots were above 8 hectares in size. We also looked at the policy statement for highly productive soils, and that policy statement uses the below 8 hectares to talk about rural lifestyle lots. So on this basis, we took the position that 8 hectares provided quite a good industry standard for the rural zone. Is that sufficient?
That's a lovely plotted summary. Thank you very much. Very concisely done. Kia ora.
Thank you.
Thank you, Ruth. We also have Tim Morris online, who is the author of the Tonkin and Taylor report in relation to flood hazards in the district.
Sorry, who do we have online?
Tim Morris, who...
right, yeah, sorry.
Yeah.
I thought yeah. Okay, so good morning, Tim. First up, with your report, has it been ground truthed? Have you visited some of these sites where rezoning has been recommended?
No, we haven't. No, we've undertaken a relatively high-level hydraulic model, and we've reconciled that against information provided by Environment Southland and Broad Terms. Whilst it's been a little bit hard to understand exactly the detailed sort of source of that information from Environment Southland and Broad Terms, our conclusions align. And I guess we would acknowledge that there is potentially some opportunity to fine-tune those lines if there was sort of more detailed or site-specific information available.
Because the panel did a field trip last week and actually visited all the sites. And there was one that stood out on Boundary Road, and I was trying to find it in the report here. So as you go down Boundary Road on the right-hand side, there's a creek and land that stretches up. Is it Wentworth Street? No, it's the other one. Maitland. Where when we look to the right, the land that has been recommended for rezoning, and hopefully someone can find it in the report here, the land that's been recommended for rezoning is clearly above what appears to be the floodplain. As you go down the road, it drops down a little bit further, but where we were sitting, it looked as though that the land is currently zoned rural lifestyle is well above the flood level. So how do we advance that?
Is this?
I guess probably necessary to look at the detail of the recommendations in the model in that location, but I guess you'll be happy to investigate that specific location further and provide some clarification on those points in terms of a right of reply if that was of interest.
I think potentially.
From what you've described, I guess I'm just not exactly 100% clear on the exact location, but certainly happy to investigate that further if that's necessary.
It shows up in Appendix C or 3, but I can't find my copy of the appendix. What page are you looking at there, Jo?
Oh, I was just looking at the Section 42A report at page 58, but I think this is in relation to land in Eastgore, which we had which was notified to be rural lifestyle, and based on the modelling, it was showing to be in a high risk area in terms of the Tonking and Taylor matrix. However, I think because obviously Commissioner Hovell, your question is very site specific, it might be worth actually getting the sort of addresses from you and doing a further look at this and then giving a response and a right of reply, given that we just need to be quite specific in what land we're talking about.
If you've got that Appendix C or 3 handy that has those 5 maps on it, I can't see my copy in the multitude of pages I've got here. Any of the other, rather than the 42A report, the separate maps, the ones that I photocopied for us all when we did the field trip.
Appendix 3 to what, sorry?
It's Appendix C, it was the mapping changes. I can bring them up online here. No. It's the one that stretches up the road. When we have the break, I'll find the appendix. I'll find it and come back to you. Okay, great, thank you.
Thank you.
But I guess for Tim's response then, how much confidence can we have on the model you've used, given that one jumps out?
The model's fit for purpose in terms of giving a broad indication of areas that are subject to heightened flood risk. So I don't think there's a problem there. It does reconcile in broad terms with the work that Environment Southland have provided, and I guess there's some areas where there is some flooding. There's there's provision for if the land is to be developed, for the developer to raise ground levels or do other work to mitigate the risk. So the areas that we were suggesting be removed from certain zones where the flood risk in terms of the Australian Emergency Management Institute criteria were quite significant.
So there's a couple of sites, and one of them was Pukerau, where your recommendation was to, in summary, the way I read it was not to allow development there. Yet in the Section 42A report, the planner is saying, look, it's part of a developed township, therefore we should be using the provisions that are in the hazards section to actually manage development on that land rather than take it out of the township zoning. Are you comfortable with that approach?
In broad terms, yes. I mean, I guess subject to the scale and magnitude of the hazard, but certainly that approach is appropriate in principle.
Can I check with you, Mr. Morris, because I'm trying to follow the logic in the Section 42A and marry it up to the expert evidence that you've given, and just thinking about where the rationale is based on location of existing development, and we might be actually controlling further development in these higher risk areas. I'm curious as to whether, say, enabling further development by raising of floor levels in a higher risk part of one of these existing developed areas, is that approach sort of ordinarily applied in other jurisdictions, for instance?
Yes, it is. I guess the focus of what we were asked to look at was, I guess, the hazard in terms of some of the areas that were proposed to be upzoned. So I don't think we've looked at the hazard in existing areas, existing residential areas, for example. But I guess in principle, if there was to be new development in those areas, then looking at managing appropriate floor levels and those sorts of things are in principle fine.
So where, say, in these zones, there are just little kind of edge areas where you hit that yellow riskier spot, so are you suggesting that even where we've got yellow and red, but only in smaller, sort of fringe amounts, if you like, I'll find the one that I've got to find the one that I was looking at, there were a couple that made me think this way. I just wanted to understand whether it was something that can be dealt with simply by adjustment to the zone, so we don't have to face that challenge of how to address further development that does look to establish in those higher risk pockets of a zone.
Yeah, I mean, I think certainly the areas towards the H5 and the H6 where we've either got estimates of deep water and or higher velocities or a combination of both, then the hazard there is significant, and it becomes more complicated and more challenging and less cost effective to do earthworks or other measures to provide a safe building platform.
Yeah, so rather than providing a pathway for that, should we be more precautionary around those pockets and areas?
Yeah. I mean, for the higher ones, yeah. I mean, I guess in terms of the example that I'm not sure exactly what one you're alluding to, but certainly.
I'll just find it. Yeah.
to provide some suggestions or recommendations to adjust zones to avoid, like for example, the H5 and H6 areas, just because, I mean, whilst, you know, if you really put your mind to it and had sort of unlimited resources, you could do engineering work to mitigate the risk, but in most circumstances it would be challenging and probably, in my view, most likely not cost effective.
Yeah, I guess it was really like Mandeville's an example where you've got this kind of encroaching of your modelling, showing the higher risk yellow areas, you know, sort of really encroaching on the outer limits of the zoned parcels, and so I was really thinking, because I know that this is why I started by asking about the difference between accommodating existing development and what we do about any further development, especially where we can see that the shape of the zone is picking up some higher risk areas.
Yeah, certainly that area in Mandeville towards the eastern side, the shading there is yellow, which indicating that flood risk is high. I guess what we were asked to look at was sort of upzoned areas that for rural lifestyle or settlement. So I don't think there's any changes to that area, but I see what you're saying, that at the eastern end of Mandeville, the flood risk is significant.
Okay, that'll do.
I've found the area that I was looking for, and it shows up on that other handout, Appendix C, recommended zoning changes. On page 2, there is an area bounded by Boundary Road and Whitewood Road, so it's the left-hand one that shows up on that, a long, narrow bit. So we were actually stopped in Boundary Road. There's a little creek beside Boundary Road that certainly makes a small area on a site unsuitable for building on, but the rest of it appears to be above any floodplain.
Okay, again, appreciate the comments in terms of the creek and Boundary Road, and I mean, if it's okay, maybe just include some specific comment on that matter in a written reply. I just not able to locate that specific location, just in terms of what I've got in front of me at the moment.
Okay, yep, that's fine, thank you.
But I appreciate the query and happy to look into that.
I'm just wondering if it might be useful for the commissioners to identify particular areas they might want a bit more focus on in a minute, so that we can respond to that in a writer reply.
That's the intent.
Yeah.
And so far, that's really the only rezoning one. There's likely, I guess the issue that we've talked about is how much do we look at the zoning of the land now versus what will come up in the hazards section. And my understanding of what we've got before us is that we're looking at the zoning of the land now and taking on board what's in the Section 42A report. Then in the case of some areas like Pukerau that have been developed, where the emphasis will be on how you use the rules to control development, as opposed to now we're looking at what the zoning should be. Is that what's intended?
Yes, definitely. I think in terms of the hazards section in general, if I can just sort of outline the way that I reviewed and have taken on board Mr. Morris's report and then reflected that in my zoning changes and recommendations, because I guess Mr. Morris has provided the report and then I've taken his advice on board and recommended these changes. So in areas such as the settlements where we do have a lot of existing development on the ground, it didn't seem, in my opinion, to align with the national planning standards and also to enable existing activities in those zones. in those areas, not to zone them settlement. And I've explained in the report that although there are areas, for instance, on the fringe of Mandeville and that eastern side, which are potentially at a high risk of flooding, and Pukerel particularly, that we can look at potentially more, I guess, stringent provisions in that natural hazard zone, even bespoke. But areas where we are proposing an upzoning to rural lifestyle, for example, where they're existing rural now, and by upzoning them to rural lifestyle, we are enabling quite an increase in development. That's where I've sort of looked at it in terms of whether or not that's appropriate. But I do understand that we can look at that property in East Gore. We also took into account where there may be existing houses there already in terms of that rural area, and by upzoning them to rural lifestyle obviously would enable an increase in houses, so whether or not it was actually more prudent to keep them as general rural zone.
Actually, I have got a question. For me, Mandeville appears to be the one that's most at risk with flooding, and it's really an outlier compared with everywhere else. And could we treat that differently, or identify to treat that differently, or are we just getting a little bit too fine-grained there?
Not necessarily, but I do think that if we were going to put more time and focus on Mandeville, then I consider that the place for those provisions to come through would be the natural hazards chapter, in that, on the basis that it's, in my opinion, not ideal not to rezone Mandeville in recognition of the activity that's out there at the moment. I also note in relation to that flood map, the area that is to the east on the northern side of the highway is the, I can't remember, the Vintage Rail precinct, so it hasn't got as much residential development or proposed residential development in that area on that eastern side. But yeah, I do think there is merit in looking at how we can manage the hazards in the settlement zones, and that the natural hazards chapter would be the place to do that, because we've got mechanisms available to us such as overlays, or so where we've kind of can have quite generic natural hazard management provisions, we can also have specific ones in relation to these settlement zones, so that we can make sure that we're targeting the different risks available. I guess all of this has sort of fallen out of the Environment Southland submissions, which were very broad brush and not necessarily helpful in terms of the district that we need to manage, and that there are different levels of risk in different areas. So rather than take a quite harsh approach and not either ground truth or upzone, where possible, we have tried to fine grain it a little bit more, and that's reflected in the reports.
It's just a comment, and I'll make an assumption, because perhaps some might say that residential land may be less expensive in some of these outlying places, that there's a certain attraction there to perhaps develop or build on something that might be a little bit more flood zone. So we would handle that, address that in the hazard section, but use the tool of specifying a higher floor level anyway.
I think just the other thing to note, because you recall in hearing stream 1, right of reply, where Environment Southland were proposing a change to an objective around hazard risk. In my response to that, I talked about high hazard risk areas, and we defined, I can't remember the term, high risk activities or sensitive activities And so you also need to factor in what the development form is. So typically residential activities are higher risk activities than, say, industrial development. And you'll hear in the hearings coming up about our response to industrial rezoning, which takes a slightly different approach because I think, Tim, some activities are less risky than others, so it's not just about the flood modelling risk, it's also about the types of activities that might end up there as a result of that zoning. So,
No, absolutely, 100%, yep, absolutely agree with that. And I mean, I guess obviously the focus of this discussion is on what's appropriate to include in the district plan, but at the end of the day, if someone wants to proceed with a house or a residential dwelling, they do need to get building consent, and the Building Act does have specific requirements around natural hazards, which includes inundation and freeboard in terms of the building code. So yeah, I guess that there's that mechanism as well.
Thank you.
It appears to be no other questions. We're due to have NZTA come online at 11 o'clock.
Just to clarify, I've got no more questions of the technical experts.
Yes.
But I do have some further questions for the Section 42A.
Yes, but rather than, I'm just wondering, rather than keeping NZTA waiting for an hour, potentially, in terms of we haven't even looked at your 42A report yet, I'm just wondering if we actually do our best to work around the submitters and use the time in between hand to come back to your 42A report. Can I just flag though that I thought it was, given the length of the report, you did an incredible job of pulling it all together. So well done, and it is helpful, notwithstanding that, well, we've got about 400 pages of material to get through, but yeah, a large job that you've done. So what I'd like, if we can, is actually just have a 5-minute break before NZTA come up online for a comfort stop.
Can we just clarify whether you still want the experts online or they're free to go?
I'm free to go from my point of view.
Great.
So
I'd like to thank the expert witnesses. Thank you very much.